Hi and welcome to the Kemp IT Law Vlog. I'm Deirdre. The European Commission recently published the final version of the Digital Copyright Directive. Member States now have until the 7th of June 2021 to implement it into national law. We've previously vlogged about the link tax and upload filters. While these issues received the most press coverage, this vlog looks at another key change: the rules around text and data mining set out in Articles 2 and 3 of the directive. The directive defines TDM as any automated analytical technique aimed at analysing text and data in digital form in order to generate information which includes but is not limited to patterns, trends and correlations. It then creates two new exceptions: a broad and irrevocable exception for research organisations and cultural heritage institutions, and a limited revocable one for everyone else. Article 3 permits reproductions of copyright works and extractions from databases made by research organisations and cultural heritage institutions to carry out TDM for the purposes of scientific research, provided that those entities have lawful access to do so. This right cannot be restricted by rights holders, although they may apply measures necessary to ensure the security and integrity of the networks and databases where the works are hosted. Article 4 introduces a fair dealing exception to copyright and database right that permits users of lawfully accessible works to copy those works for the purposes of TDM. This right is conditional on the user having lawful access, i.e. a right or license to use the work in the first place. The exception can, however, be disapplied if expressly reserved by rights holders in an appropriate manner. This may take the form of machine-readable means in the case of content made publicly available online. The reference to an express reservation raises the interesting question of whether the existing practice of saying "all rights reserved" or "all rights not expressly licensed under this agreement are expressly reserved" will be sufficient to exclude the Article 4 right. For rights holders, we'd recommend that the implementation of the directive into national law is monitored to ensure that any local requirements on the reservation are complied with. In the interim, we'd suggest that any reservation of rights wording specifically and explicitly restricts TDM. For users, it's important to check the license terms and to look out for references to what's permitted. To understand the applicable law in the jurisdiction in which you're based, please remember to check documents, websites, platforms, etc., as well as formal license terms and T's and C's to find out what they say about text and data mining. If you'd like to know more about the Digital Copyright Directive, please see our vlogs at www.kempitlaw.com.